We are in a very litigious area, special education. Approximately, I mean, if you think about it, in special ed, most states are between 10 to 12% of our public school population is special ed, 10 to 12%. Yet, and that's true nationally, 10 to 12% of public school kids are special ed kids. Yet, about 90% of all education litigation is special education litigation. So most of litigation education is from special ed. And then of course you have state complaints that folks can make that get investigated by the state, and you have complaints under 504 that can go to the Office of Civil Rights. So we're in a very litigious area. And of all the cases, when I say litigious, I mean due process hearing, Tier 2, SEA hearings, federal court cases in district court, appellate court, or even up to the Supreme Court. We're in a very litigious area. Like I said, 95% of all education litigation is special ed. Of that, about 90% is FAPE, are FAPE issues. FAPE issues are free appropriate public education. And you know, they all boil down to one place, and that's the IEP. They all boil down to the IEP. I mean, when Jim Walsh was talking about the Andrew case, and the other day David and I were doing the pre-conference on the Andrew case, it all started at the IEP table with disputes between parents and school districts that cannot be settled and wound up going into the courts. Now, FAPE is the major issue, like I said, and the IEP is a blueprint of a child's fate. So that we need to really get correct. So what we're going to talk about today is something the Supreme Court talked about in the Andrew case. Justice Roberts wrote the Supreme Court decision in which he said, well, let me get into that in a second, what Roberts said. But first I want to just talk about a couple things. And one of the things is, because we're so litigious, there's constant litigation, constant decisions out of OSEP, the Office of Special Ed Programs in the U.S. Department of Education, constant decisions out of the Office of Civil Rights that involve youngsters with disabilities, state complaints. Our field changes so rapidly because of litigation. Now, our law doesn't change. I mean, the Individuals with Disabilities Education Act hasn't been changed in Congress since 2004. It used to be reauthorized or amended about every 5-6 years. Now it's 15 years. It hasn't been. And actually, now is not a real good time for it anyway, so it's not on anybody's radar. So our law is not changing. The law itself, the idea, doesn't change. Regulations don't change. Regulations are written by, when a law is passed, Congress delegates a certain amount of authority to administrative agencies to do what's called promulgating regulations, or they write the regulations that help school districts understand how you have to, and states, how you have to implement the idea. They fill in the gray spots in the law. They haven't been changed, and they're always changed. The U.S. Department of Education is the administrative agency that writes regulations implementing the idea. They haven't changed since 2006. So the law itself hasn't changed, and I don't even think states can change the law. Of course, Article 7 hasn't been, I don't believe, been changed for quite a while. When was the last time?
Just revised in May.
Oh, they just revised it? Did they actually change anything?
Intellectual disabilities, terminology, but nothing, no major, just no procedural.
Yeah, so states do that a lot because, as you know, IDEA is a federal law, and we have to follow the federal law, but we also have to follow state law, because one of the conditions on when the IDEA was passed, way back when it was called, if anybody remember, PL 94-142, or the Education for All Handicapped Children Act, one of the major tenets of the law was if you have to meet the rules, the law as, well, I should say, one of the major tenets of the law is all states, to buy into the idea, had to develop their own policies and procedures that met the federal law. and all states essentially passed their own version of the idea. But states cannot offer, in their special ed laws, which you have to follow, they can only offer more than the idea. They can't offer less. So you have, for instance, one of the differences in Indiana in Article 7 is in the federal law, transition services, you don't have to begin doing transition services until a child is 16. That's what the federal law says. But Article 7 says 14. And so what does that mean? That means that Indiana has chosen to actually require more of school districts than does the idea. So you have to follow that. Now, Indiana couldn't have said, well, you know, we think we're not going to begin transition services until 18, because that would violate the federal law. You can't do that. You can offer more, but you can't offer less. Now, Indiana does do some things differently than federal law. Like you have to address extended school year services in your IEP in Article 7. That's not a federal requirement. But so the federal law hasn't changed. The state laws do change periodically, little changes, but they can't be in violation of the federal law. And the federal law, but what does change is litigation. Litigation is constant in the area of special education, and that helps us to understand what we need to be doing. Also, what does change a lot in special education is the Department of Education, which writes the regulations. They have 2 offices in the department. One of them, they have 16 offices. 2 of them are important to us as special educators. One of them is called the Office of Civil Rights. The Office of Civil Rights is responsible for implementing Section 504 of the Rehabilitation Act. That's what they do. The Office of Special Education Related Services, or OSERS, has an office within it you probably heard of called OSEP, the Office of Special Ed Programs. Now, OSEP will frequently issue letters of finding or policy guidance, which are important to us. They're not as important as a law, but they're the U.S. Department of Education essentially saying, this is how we think you need to implement the law in order to be in compliance. So, for example, OSEP has put out a number of letters on bullying. There's nothing in ID about bullying, but they've interpreted a number of laws in such a way as to be important to special educators. Like saying, for instance, if you have a child that's bullied and you know about it and you don't do anything about it, that's a FAPE violation. The law doesn't say that. OSEP said, watch out, that's what we think it is. And in fact, the court said, yeah, that can be a FAPE violation. So it's really important to keep abreast of developments in the courts and policy letters from OSEP and OCR, because they very much involve us. Just last hour, I was talking about response to intervention, multi-tiered systems of supports. There's nothing in the federal law about that except with respect to identifying kids with learning disabilities. Yet look at our schools. MTSS is probably one of the great educational innovations of the last 50 years if it's applied properly. But OSEP has issued letters because they were concerned that it wasn't being applied properly and kids were being denied a special ed evaluation and schools were violating their child find duties. So you see, those letters come out, they're very important. So we need to keep abreast of litigation. We need to understand what OSEP's telling us. Now, the question is, how do you do that? And myself and, there's a lot of good websites that are available, but myself, David Bateman, and a professor from the University of Arkansas named Kevin Brady have started this thing called the spedlawblog.com. And what we're doing is taking turns. About every 2 weeks, we will update that with anything we think is really important that we need to know. If it's a new case, we'll have a blog on it. If it's a new OSEP ruling, an OCR ruling that we think you need to know, we'll put a blog on that. So I just wanted to start with that just to let you know that things change all the time. The law hasn't changed, the regulations haven't changed, but special ed has changed because of OSEP rulings, because of litigation. So what I wanted to talk about today is IEPs, specifically writing goals that meet the requirements of the law. And in a way, I mean, we can't talk about just writing goals because the important thing to understand about IEPs is they are a blueprint of a child's fate. Remember, 90% of all litigation in special ed is FAPE litigation. It's parents contending the school district has developed an IEP that does not confer FAPE or a free appropriate public education. One of the most important things that we need to understand about developing our IEPs is the IEPs have to be internally consistent. And let me give you an example. About 2 months before the Andrew decision, which Jim Walsh talked a little about in 2017, which was a FAPE decision from the U.S. Supreme Court, which is the law of the land. Of course, that's when a decision comes out of the Supreme Court, that is law of the land. It has to be followed. About 2 or 3 months before that, I had a level 2 case in a special ed FAPE case that was a hearing that had appealed to me as appealed to the state. Barbara Drayton, the state attorney, called me up and said, "Would you hear this case?" Well, I don't hear it really. What I do is I read it and then match it to the idea. And so I got this case, and it had been a case that was appealed by parents. It was a FAPE case involving a young girl with an intellectual disability who was in a public school, and the parents disagreed with the IEP. They said it did not provide FAPE, and that's the just grist of virtually every FAPE decision is parents have disagreed with school district's IEPs, and it goes through the process, due process hearing, and this Andrew all the way up to the Supreme Court. Well, in this case, it had been heard at the local hearing level, which means the hearing officer, who I knew was an attorney, knows a whole lot about law, was the hearing officer. And they heard it right at the school district. Both sides had their attorney. Well, no, wait, it was what we call a pro se case. Parents didn't have an attorney, they represented themselves, which is usually a bad idea for parents because attorneys can make all sorts of motions that essentially parents don't answer. That could be the end of the case. But at any rate, the father had done a pretty good job of arguing this case. Not so good, but made some mistakes. But when I got the case, what had happened, the hearing officer had said school district had delivered FAPE because they had met all the requirements of the law, of the idea. So then what's my responsibility is to read the transcripts, the 1,200 pages of transcripts, go through all the evidence and make a decision. Did that hearing officer, was he correct in ruling that the school district had provided FAPE? Well, the first thing I did was, of course, I read the transcripts, got an idea of what they were arguing, and they were just arguing that they didn't deliver a free, appropriate public education. So the first thing I looked at was the IEP. There was actually 3 years of IEPs. And what's the first thing you see in an IEP? The present levels of academic achievement, functional performance. So I went right to those, and what I found out is little Amy, her name was Amy, had some pretty significant needs in reading and math, and some behavior problems. So I read all the present level performance statements. They weren't great, but they weren't bad. Math, reading, and behavior problems. Oh yes, and communication. She needed speech. So the next place I went to was the goals. And the first thing I always looked for is the IEP internally consistent. You look at the present levels. Were there goals? Were there services? And I look at the present level statement, and I found a bunch of reading goals, a couple communication goals from the speech and language pathologist, a couple behavior goals, no math goals. said, oh, that can be a problem. So I went to look at the services. Because if you have a need, you've got to have a service. And I found reading services, communication, behavior, up, no math services. So they said, the IEPs, 3 years of them, said math need, never addressed in the rest of the IEP. Boom. That's an illegal IEP. That didn't provide FAPE. Why? It didn't address her needs. So that's why it's really important that we, first off, always think in the mindset, internally consistent IEP. Needs must be addressed by goals. Goals must be addressed by services. Now, not all needs need have a goal. Sometimes you'll have a goal or a need that can be addressed just in modifications or accommodations, and that's fine. But you gotta have a service. You have to have a service. If it's a special ed service, a related service, accommodations, if you got a need, it has to be addressed. And it's reading or math or something like that, behavior, it should have a goal. So I'm going to be talking mostly about writing measurable goals, and I'll get into that in a while. But you can't divorce that from present levels and the services. They all fit together. As I said, they have to be internally consistent. Now, before we begin, Jim spent a little time, and 2 days ago in the pre-conference, David and I spent quite a bit of time of talking about the Andrew case. Andrew F. v. Douglas County School District. Now, you've all heard of that case, I imagine. It's a pretty important case. It's the second time that the Supreme Court has addressed the issue of what is a free, appropriate public education. What are our responsibilities to develop a free, appropriate public education in a student's IEP? And of course, because the IEP is the blueprint of FAPE, that's what the Andrew case, that's what it looked at. It looked at the IEP. Now, this case and the Rowley case, which was heard way back in 1982, the Rowley case involved a young girl with hearing impairment, who was actually deaf, who was academically able, very bright. She had an IQ of measured at various points from either 125 to 140, very bright child, passing from grade to grade, having no problems. So the Supreme Court didn't really have to address, was she getting an appropriate education? But in Andrew, little Andrew F. had autism. He was his communication was impaired. He had serious problem behavior. Academically, he was really having problems. So the courts really had to struggle with what is appropriate for kids, like most kids are in special ed, who have some fairly significant needs. And they did that. And what they did is they issued a ruling in which they decided unanimously that Andrew F. had not received a FAPE, not received a free, appropriate public education. And here's what they said. This was their main holding. The court, Chief Justice John Roberts wrote in his decisions, IEPs must be reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And so in other words, what we need to do, according to the Supreme Court, is write IEPs that enable the children to make progress appropriate in light of their circumstances. In light of their circumstances, meaning kind of in light of their unique educational needs. Our IEPs must allow them to make progress. Now, also, a few other things the court's Chief Justice John Roberts wrote is students must have challenging goals and objectives, if appropriate, and a student's program must be appropriately ambitious. That's an important term. Not so much, well, who knows legally, because this case is now it's going down the courts, and there's lots of decisions going to be coming on when do schools meet the Andrew decision. But what we know is they have to allow a child to make progress. We have to have goals that are challenging, and they must be appropriately ambitious. Because, as Chief Justice Roberts wrote, the essential function of the IEP is to pursue academic and functional advancement. Keep that in mind. Now, in terms of the IEP, the two Supreme Court decisions have essentially said there's two areas that we have to make certain we're compliant with in writing our IEPs. The first area has to do with the process, how we develop the IEP. One of the things that, has anybody ever here read the idea? I don't know why you should or why you'd want to, but let me tell you, if you suffer from insomnia, take that sucker to bed with you some night and try and read it. It'll put you to sleep right away. But because one of the things, it is very specific about the processes that we have to follow in developing an IEP. And basically, the whole purpose of the processes, these procedural hoops we have to jump through, are to ensure that parents are meaningfully involved in a child's development and that we write a program that allows the child to achieve and that we evaluate the progress. All those kind of things that we usually think of in terms of kind of how we have to do it, who we have to have on the team, when we have to have the things done. Those are process issues. The Supreme Court in the Rowley case that I was talking about in 1982, they said that process is very important. In fact, when any hearing officer, any court gets a FAPE case, they have to apply the Supreme Court's test. In the Rowley decision, they had a two-part test. And the first part of the test is you got to get the process right. You have to have a procedure. You have to follow all the procedures of the idea. So that's very important. In the IEP, we want to make certain parents are involved, that we have the appropriate IEP team members there, that we give parents enough notice to be there, and all those kind of process issues, we've got to follow those. But secondly, it's also, by the way, the document that proves that, because that document becomes a child's FAPE. That is the child's FAPE. 95% of all special ed litigation is about that very thing, the document. And courts are going to make sure, number one, that we followed the process. And number two, they're going to make certain that the IEP is reasonably calculated to enable a child to make progress in light of this child's circumstance. How do we do that? That's what we call the substantive part of the idea. Julie Weatherly is here speaking. She talks about that as the content requirements of the idea. That means in terms of the present levels of performance, the goals, the services. That's the substantive part of the idea. That's the part that has to enable a child to make progress appropriate in light of his or her circumstances. Now, these are all the like I said, these are the how and when issues, the procedural requirements. We've got to make sure we do those. I know a lot of states, one of the things I'm doing is right now I'm serving as an expert witness on a Department of Justice complaint in Florida, where parents were complaining to the Department of Justice that schools are violating the ADA, Americans with Disabilities Act. Well, that's the same thing basically as Section 504. I'm not sure why the parents complained to the Department of Justice instead of the Office of Rights, but they did. But that's one of the things that was alleged, is that the schools did not follow the process. They didn't do the how and when stuff correctly. That's the first part of the Rowley test. So anytime I get a case on FAPE, or any lawyer or any hearing officer, that's the first thing they ask. Did the school comply with the procedures set forth in the law? And we know, those kind of procedural things are stuff like this. Informed parental consent, parent involvement, team members, components, monitoring progress, all those kind of things. They're just procedures of the law. We all know what those are, but it's very important that we follow those. Now, in terms of components of the law, this is the substantive part. It's actually kind of interesting. It's a procedural and substantive issue in terms of the components of the IEP. Because if you don't have any of these things here in the IEP, if any of these things are missing, and ESY and LRE statement, I put an asterisk because those are required in Article 7, but not in the federal law. So you have to meet those too. But if any of those things are missing, you've made a procedural error. But you also are making a substantive error. Why? Because how is a child going to make progress if you didn't address all the needs of a child? So by getting the present levels wrong, you committed a procedural and a substantive error. By getting the goals wrong, you're committing a procedural error if you leave them off. But if you'd have bad goals, that is a substantive error. Because the substance is essentially means what the IEP did. How did it allow the child to make progress? So you kind of get that distinction? It's a real difficult one. Courts have been struggling with it for years. But here's the issue about the substantive. This is what Andrew was about. The Andrew case wasn't about procedures. They said the Supreme Court was right, you know, back in 1982, when they said the #1 test a hearing officer has to apply is, did the school follow the procedures? But they said the Supreme Court wasn't quite right about the second part of the test. Because remember, I said Amy Rowley was a high-achieving child. Andrew was not. And what the Supreme Court said back in Rowley is, well, Amy was passing from grade to grade, so clearly she must have had a meaningful IEP, but Andrew wasn't. And he had those very serious problems. And in fact, Andrew's parents had pulled him and put him in a place called the Firefly Autism House, and then sued the school district for reimbursement, which of course a parent can do that. I mean, if they decide that your IEP doesn't confer FAPE, they could say, hey, we're moving our child to a private school like Firefly Autism House, and then we're going to sue you and you have to pay us tuition. Firefly Autism House costs $70 grand a year. They pulled Andrew out, put him in that school, and he did well. So for parents to sue school districts for tuition reimbursement, they have to convince a court that #1, you didn't offer FAPE, #2, that the school where he went was a good school. And if they're convinced of that, school owes them tuition reimbursement and attorney's fees. Well, one of the major reasons that the Supreme Court eventually, and the district court eventually said school district did not offer Andrew a FAPE is because they repeated the goals year after year after year. They had the same goals in 2nd grade, in 3rd grade, and in 4th grade. And what Barbara Bateman, she's one of the grand dames of special ed, she was an attorney who retired out of Oregon, she said one of the things, if you write an IEP that has goals that don't change year from year, you might as well stamp does not deliver FAPE on the cover of the IEP. That can be a real problem. Maybe not, but in many cases it is. But these are the substantive requirements. They represent the what of the Individuals with Disabilities Education Act. And that's where Chief Justice Roberts wrote, a student's IEP has to be reasonably calculated to enable a child to make progress appropriate in light of his or her circumstances. So if we look at the legal substantive requirements, that's the second part. So if I get a FAPE case, when I get home, I'm going to use Part 1 of the Rowley test and then the Andrew test to determine if the school is offered FAPE. Part 1, did the school follow the procedures? Part 2, was the IEP reasonably calculated to enable the student to make progress in light of his or her circumstances? It's not hard for me to make a determination of procedures. All I got to look at is, how did you do it? Were the parents involved? Yes. Were all the components there? Yes. Were all the IEP members there? Yes. You know, the procedures are kind of like checklists. If they're all done properly, you're in like Flint. The second part is a lot more difficult, though. That's when I would have to look at the actual IEPs to determine if they substantively allowed the child to make progress, or enabled the child to make progress in light of the child's circumstances. Now, these involve things like this. I'm going to have to look at the assessment. I'm going to have to look at the present levels of academic achievement and functional or performance statements, the measurable annual goals. I'll look at the services. I'll look to see, did the school monitor students' progress? And very importantly, I'm going to look at and see, was the IEP internally consistent? If it's not, if a school falls down in any of these areas, and instead of services, I wrote research-based programming, because in 2004, the idea included a section that said special ed programming must be based on peer-reviewed research to the extent appropriate. So I'm going to look at these four things to determine if the IEP was reasonably calculated to enable a child to achieve services. Excuse me. Enable a child to make progress, because that is the substantive standard. That's what the Supreme Court said it was. That is the law of the land. Now, the big picture issues of the idea really have to do first with the very baseline. The baseline of our IEPs are in the assessments that we do. Assessments must address all of a child's needs. All of a child's needs. Doesn't matter what their disability is. I mean, there was a case just a few years ago I read. It was a due process hearing involving a child with a learning disability. And the school had said, no, we're not going to. The IEP team they had documentation on this. Basically, it said, yes, the child does have problem behaviors, but he's not emotionally behaviorally disordered, which is the criteria in the particular state to get services under EBD. So they said, we don't need to address behavior. Well, that's nonsense. Of course you need to address behavior. You need to address all of a child's needs. Doesn't matter what you call them. Courts don't usually care that much about what the label is. They just care that the needs are all addressed, like the law requires. So that's very important, that our assessments are the baseline of our IEPs. Everything comes after the assessment is based on the assessment. So to the extent that that's wrong, probably everything else is going to be wrong. And of course, those have to be reflected in our present levels of performance statement. Now, next, we have to understand assessment's really about two things. Initial assessment is about determining eligibility. Because, we have 13 disability categories. It's kind of like an entitlement program. The child has to have a disability, and because of it, they need special ed services. That is required. But we also have to understand the assessment is the baseline of the IEP, that it's got to be thorough enough that we address all those areas of potential need. Because we write the IEP based on the present levels of functional academic achievement, functional performance, which address all functional and academic needs. So that's kind of like the foundation of our IEP. Next part is we develop our programming. Well, what's the programming look like? It's our measurable goals. It's the special education and related services that we provide. And the third part of the triangle is the monitoring of student progress. That there are two types of evaluations that we do: formative evaluations and summative evaluations. Summative evaluations are evaluations at the end of the year or the end of a unit. They're at the end of instruction to see how a child did. Well, one of the problems with summative evaluation, and Congress recognized this back in 1990, a problem with summative evaluation is once you get the results, can you go back and change instruction? No. Once you get the results, that's the results. it doesn't do the child any good if you get results that said after a year that, oh, gee, the child didn't do very well this year. What can you do? You can't do anything. Well, we'll try harder next year. So what Congress did in 1990 is essentially mandate what's called formative evaluation, that we monitor students' progress during the course of instruction and then report to a child's parents how they're doing. And clearly the implication is they're not doing very well. We can make a change at that point because it's formative. Now, in terms of the present levels of academic achievement and functional performance statement, again, it must be based on a full and individualized evaluation. Now, during this evaluation, the team might, if it's an initial evaluation, is looking for eligibility to gather eligibility information, but very important, they're also looking at the student's academic and functional needs to write the IEP from. So you have to have that information to base the IEP upon. Now, a few years ago, David Bateman and I were presenting in Washington, and Larry Wexler, who's the head of research and practice arm of OSEP, came up to us and he said, please, when you talk to people, emphasize that we are not just about academic achievement. We're about functional performance too. So in other words, if you have, and what is functional performance? It's defined by the federal government as non-academic areas necessary for living independently. It's behaviors, communication, socialization, issues like that. OSEP has been really concerned that oftentimes we don't address functional information in our present levels. But if a child needs it, we have to provide it. We also have to, and this is a federal law, federal regulation, I should say, that we also have to explain the effect of a student's disability on their involvement in and participation in general education. So in essence, the federal law and regulations require 4 things that we do in the present levels of performance statement. First, that we identify a student's need, if it's reading, if it's math, if it's behavior. Second, that we say what the effect on general education is. Third, that this will serve as the baseline of the rest of our IEP. So it's very important that we get those right. And finally, that if we have an internally consistent IEP, your needs have to be connected to a goal, service, or both. So think of those four things as really important. And let me just mention this. A number of years ago, and I may even have this quote later in the presentation, but a school district, and this has happened a lot, school districts have often lost FAPE cases based solely on an inappropriate assessment. Solely. Because, as one court said, the assessment is the foundation upon which the IEP is built. If the foundation is bad, the walls will tumble. Essentially, the court was saying, you get that wrong, you're going to get everything that follows it wrong too. So that's very important. Now, the second really important thing in terms of FAPE and IEPs is figuring out where we're going to go from the present levels of performance. And of course, this is our friend the Cheshire Cat who said, if you don't know where you want to go, it doesn't matter what path you take, does it? Because we need to determine where we want to go and how we're going to get there. That's what the goals and the services are all about. Where we want to go and how we're going to get there. What is reasonable? What can we reasonably expect a child to achieve in terms of, in 1 year's time, given our expertise as special educators, what can a child achieve in 1 year's time? That's what a goal is. Now, you've probably all heard this terminology before. Measurable annual goals should be SMART. Many different writers have used this terminology, and they've actually used kind of different terms, but it's a good analogy because I think it says exactly what we need to understand about our goals. Number one, they have to be specific. If you have goals that are too general, they won't pass legal muster. They have to be specific. You target a specific area. They have to be measurable. There's no way that we can show progress if we can't measure goals. It just can't be done. And Jim Walsh was talking about the importance of data collection. Absolutely important. You have to be able to measure goals to collect data. If you can't measure the goals, what can you say? You know, the child looked happy, he seems to be happy or whatever, but if you have measurable goals, you can say the child did reach their goals because you can measure them. Perry Zerkel, who's also your, has written that FAPE, substantive FAPE issues will be decided on the IEP's actual results or likely results. If we write an IEP that we can't measure, how can we say this is going to make, allow a child to make progress if we can't even measure it? So that's very important, measurable. Third, ambitious. Goals have to be ambitious. They have to be reasonable, though, and they have to be time-bound. Or they have to have a year, at least be written. A measurable annual goal is exactly that, annual goal. We write them for 1 year's time. Now, in terms of specific, remember, specificity, academic, and functional needs. So if we have those needs in the IEP, we have to address both type of needs. Remember the case I was talking about where they had a behavioral need, they addressed it. They had a communication need, they addressed it. They had a math need, oh, they didn't address it. That violates FAPE. That is not a specific goal. Goals need to be, they're essentially a mechanism for determining if a child has made progress. That's the new Supreme Court's watchword in determining FAPE. Does it enable a child to make progress? If we don't have goals that are specific or measurable, how can we say we're going to use that to determine a child's progress? Also, this is, I think, the case I was talking about. The Rio Rancho Public Schools is actually a state-level hearing in New Mexico. Annual goals were not measurable. What happened in this case is the State Department of New Mexico said, school district, you have 2 years of IEPs that are illegal. They didn't provide FAPE because they weren't measurable. They said the hearing officers, the panel of hearing officers wrote, the students' annual goals and objectives in each IEP simply do not contain objective criteria which permit measurement of the student's progress. A goal of increasing reading comprehension or improving decoding skills is not a measurable goal. So both IEPs, 2 years of IEPs, had reading goals of increasing reading comprehension, improving decoding skills, but they didn't say to where. To where is the child going to be? How are we going to know if the child has reached those goals? Because they weren't measurable. They just said, will increase, will improve. That is not sufficient. Even if the present levels of performance statement were clearly stated, which in this case they were not, an open-ended statement that a student will improve doesn't meet the requirement for a measurable goal. Now, why goals should be measurable? Back when I started teaching special ed, you only had to write goals, and the objectives had to be measurable. Back in 1990, the goals for the first time, the law said goals have to be measurable, not just objectives. And if goals aren't measurable, or if they are measurable and we didn't measure them, we can't show progress. Goal doesn't meet the substantive requirements of the Andrew case. Another example, Escambia v. Benton, case out of Alabama. Mushy, this was a kind of interesting case. We had a judge who I think really had wanted to be a writer because he had all this flowery language. He said, the mushy, ambitious, unquantifiable goals often listed in Benton's IEP are at odds with the idea. Vague and unmeasurable objectives are the handmaiden of stagnation. as a program cannot possibly confer an educational benefit for Bentons if his teachers and parents do not know where they're trying to take Benton and how they will know when he has arrived. So in essence, he was saying, you've got to have measurable goals. If they're not measurable, they can't possibly confer educational benefit. That was 5 years, I think, before Andrew. It's a lot more important now, because now the standard isn't educational benefit. The standard is now progress. Progress implies moving forward, movement towards something. So it's more specific than it did. And there was another, I chose to not put this one down, but the judge also wrote something like, the school personnel were like children in a party with a blindfold trying to pin the tail on the donkey. Because he was saying, you just don't know where you're going if you don't have measurable goals. And he was kind of a little bit wordy in the way he did it, but he was right. Also, goals need to be ambitious. Now, remember, this is what Andrew said. The essential function of an IEP is to set out a plan for pursuing academic and functional advancement. That's from the Supreme Court. And here's another one. And Jim Walsh talked about this. A reviewing court may fairly expect school authorities to be able to offer a cogent and responsive explanation for their decision that shows the IEP is reasonably calculated to enable the child to make progress appropriate in light of a child, or make progress appropriate in light of that child's circumstances. They have to be ambitious. Now, again, they have to be reasonable, but err on the side of ambition. And here's why. Case Carter v. Florence County 4 out of South Carolina. It was a case that went from the IEP team to the due process level, two-tier, second-tier hearing officer, federal district court, U.S. Court of Appeals, all the way up to the Supreme Court. And this case involved a young girl named Shannon Carter. Shannon was in 9th grade, a student at Timmonsville High School in South Carolina. So poor little school district, District 4, Florence County 4. Shannon read at a 4th grade level. Okay, the school district made a lot of mistakes in this case. One of the big mistakes had to do with the goals that they wrote for Shannon. Because remember, she was in 9th grade reading at a 4th grade level. Well, the goals were written in such a way that even if Shannon had met those goals, it would have done her little good. Because as the Justice Houck, our federal district court judge, wrote in this case, the stated progress on Shannon's goals in her IEP on reading and math skills for an entire school year ensured the IEP's inadequacy from its inception. Even if Shannon had met her goals, she would continue to fall further behind her peers. The goals were wholly inadequate. Florence County 4 failed to provide Shannon with a free, appropriate public education. You know what the IEP team did? She was in 9th grade. They wrote an IEP for her that had goals in reading and math that called for Shannon 1 year's time to make 3 months growth on the Woodcock-Johnson. Now, she was a bright kid. She was a fairly bright kid. Not a Amy Rowley bright, but she's bright enough. She couldn't read. She's in 4th grade in special ed, in 9th grade in special ed, reading at a 4th grade level, and they said her goals were set for 3 months worth of growth in 1 year's time. The judge said, that's wholly inadequate. That is not an ambitious goal. So I always tell folks, err on the side of ambition. You know, we want to be reasonable, but schools have never lost because they were too ambitious in writing their goals. They often lose because they're not ambitious enough, because a court would look at that, or a hearing officer, and say, that is not a meaningful goal. The child is not going to make progress appropriate in light of their circumstances. So that's why I say, I think the A part is very right. We need to be ambitious, but be reasonable. I mean, Shannon was reading at a 4th grade level. in 9th grade, but I think it probably would have been unreasonable, say in 1 year time, she'll be reading on the 12th grade level. That wouldn't make any sense. So you don't do that, but you draw on your expertise as educators to say, if we put together a real program, what can we reasonably expect? And we need to remember, Supreme Court is challenging and appropriately ambitious. Now, we're really, our purpose really is, I want to spend a little time talking about a way to write measurable goals. Now, there's not the only way. And I know the IEP Center does a lot of work on writing measurable goals. And essentially, the seminal work on writing measurable goals was this little dude over here named Robert Mager. Wrote a book in 1969 called Preparing Instructional Objectives. It wasn't about special ed. Special ed wasn't a thing until 1975. But he wrote it. He was actually an efficiency expert in the U.S. Air Force. And he was in charge of increasing efficiency in motor pools and mechanical areas. And so he developed this method of writing goals that were measurable, because he said, if you can't measure a goal, you can't determine, I mean, we need to have measurable goals to see if our servicemen are doing their jobs, are doing them efficiently. When he got out of the service, a friend of his convinced him that, boy, this is a real effective way for educators to write goals. So he wrote a book in 1969 called Preparing Instructional Objectives, and I was a student in history at the time, preparing to be a history teacher, and our professor required us to use it. And then years later, I thought, boy, this is a great way to write goals, because what Mager did is he came up with a method, a 3-step method of writing a goal, that if you write it that way, you can't help but writing a measurable goal. And the 3-step method was this. And by the way, I added one thing to it because of idea. Because of course he wrote this way before idea. But these are the 3 things he said, and the 4th that I just added. He said, number 1, whenever you write an annual goal, you have to have a target behavior. And the important thing about target behaviors is they must be observable, measurable, verifiable, repeatable, can be counted, like frequently, to write, read aloud, point to something you can count. You don't want to write goals that are invisible, open to many interpretations, like to understand, to enjoy, to improve, to increase, to develop, because those words by themselves aren't measurable. You've got to put a number in there, so they must be observable. That's the target behavior part. Second part is what he called the conditions, or what Barbara Bateman, in a book she wrote, called them givens. And that is, how are you going to measure the goal? So in your goal, you have to have the target behavior, you have to have the given. Now the given is, how are you going to measure it? What's the content? Our materials? What's the environment? Is there a measurement device you're using? That's the condition or given. Now, Barbara Bateman calls it given because oftentimes in our IEPs we'll write things like, given a story starter in 3 minutes to write. Given a story starter, that is the given. That's how we're going to measure. Or given oral reading fluency, oral reading passage, Johnny will, so that given, an oral reading passage, that would be our given or condition. Now the third thing Mager said we need to have a measurable goal is a criterion for acceptable performance. That tells us if the goal's been achieved. If we don't have that, we can't measure it. How can we possibly measure a goal if we don't know where we're going with it? In terms of the criterion for acceptable performance, that's how we know the goal's achieved. That includes maybe things like number correct. So given a list of 100 basic math facts and addition, subtraction, multiplication, and division, Jeremy will answer 90% of the facts correctly, or something like that. That's a criterion. Given a story starter and 3 minutes to write, Jeremy will write 24 correct word sequences, or 24 words correctly spelled. Those would be ways we can measure if the goal has been met. So you can have terms number correct, the speed in which a child will do something, the quality, fluency, data, but the important thing is it's got to be numbers. It has to be data. It has to be something we can measure. If we can't measure it, we can't show that a child has made progress. If we go back, last thing, timeline, that's just kind of idea, requires that we have a timeline. When is the goal to be achieved? What's the date? Usually 1 year, 1 year from or an annual review date, or 1 year from the writing of the IEP, because a measurable annual goal is, according to federal law in Article 7, 12 months. It is for the school year. So if we have all those things down, we have a measurable goal. And by the way, you can put in the measurement device too. Instead, you know, when I say given a story started 3 minutes to write, well, the measurement device, what is it? It's a curriculum-based measurement. So these are the things that are important about measurable annual goals. Target behavior that's visible, got to have that. Conditions are given. How are you going to measure it? What's your measurement device? What's your criterion for acceptable performance? Should have put this one over there. And then the timeline, 1 year's time. Those things have to be present. According to Mager, these first three things, if they're not present, it's not a measurable goal. And if you don't have those things, how can it be measurable? How can you possibly prove that the IEP is reasonably calculated to enable a student to achieve progress if you can't measure the progress? You've got to have that down. Now, I just want to take a few seconds here to talk about the good, the bad, and the ugly. Has anybody ever seen this movie? It's a great old Western, but we have plenty of examples of IEP goals, and I'm sure you've seen plenty of examples of good goals, bad goals, and ugly goals. A couple years ago, a friend of mine, Jim Schreiner, and I applied for a grant from the Institute of Educational Sciences. My part of the grant was to, with a colleague of mine, Eric Drasko, to develop a tool to measure the substantive quality of an IEP. And as we collected hundreds and hundreds of IEPs, and one of the things we did, read through every one of them, looked at the goals. I have a lot of good examples. No, well, let me say it this way. I have a lot of bad examples. I have a few ugly examples, and I have a couple good examples. I mean, good, you know, if you take time to go through goals in IEPs, you'll find that most of them aren't measurable. And it's not that teachers and IEP teams don't want to write measurable goals. It's oftentimes that they just really kind of don't know exactly how to do it. And for old folks like me, we weren't required to do it in the first days of the idea. We're now required to do that since 1990. So let me give you examples here. This is an example of good. That's Clint Eastwood, if you can't tell. He was the good. You had to figure that. By the next, and this is a real IEP goal that I took from an IEP in upstate South Carolina, which upstate South Carolina, Greenville Public School District goes big in, they're really big into CBM, curriculum-based measurement, so they write their goals in accordance with CBM. Well, let me tell you, if you write them properly, a CBM goal can't help but be measurable. And this is an example of what they did for this little dude. By the next IEP, when presented with a second grade reading passage, Blondie, that wasn't his real name, will increase the number of correct words per minute he reads aloud from 32 to 104 as measured by a curriculum-based measurement probe. So, let's look at that in a little more detail. Number one, by the next IEP, that's the timeline. They could have said by May 16th, 2019, whatever. That was the timeline. Next thing, when presented with a second grade reading passage, that's the conditions. That's the given. When presented with a second grade reading passage. Blondie will increase the number of correct words per minute he reads aloud. That's the target behavior, reads aloud. It's measurable. You can see it. You can count the words he's read aloud. From 32 to 104, that's our criterion for acceptable performance. That is what, that's how we know that Blondie is going to meet his goal when he can read 104 words a minute. Now, they made a professional opinion that we think, given a good program, he's going to make those kind of gains, which actually comes out to, I think, about 2 words per week, which is very ambitious, but they thought we could make it. And again, school districts don't get in trouble for writing goals that are too ambitious. Maybe if they're crazy out of the world ambitious, but it's unambitious goals that'll get you in trouble. And they also put in measurement device, which is curriculum-based measurement probe. Now, that's an example of a really good goal. It's got all the major stuff. It's got the timeline, the measurement device, which are kind of extras required by the idea. Again, it's not the only way to write a goal, but it is a way to write a goal. But in my mind, if you don't have at least timeline, conditions, and target behavior, you can't measure it. Got to have all 3. This is another goal. Look at this one. Angel Eyes, Lee Van Cleef, the bad guy, will improve written language skills as measured by increased scores on the language section of MAP. Measures of academic progress is a test that is given for progress monitoring purposes in South Carolina. Okay, so that is what they're saying is he's going to get better language scores on his MAP. So let's look at that and compare that to what Meagher talked about in terms of writing a measurable goal. Angel Eyes will improve. That supposedly is the target behavior. But how can you measure improvement? There's nothing in there that really will allow you to measure improve. It's not measurable. It's not countable. You know, and look back at Blondie's. It was will read aloud. You can count the words he read aloud. You can't count improvement unless you have something that you want to improve to. But look at somebody. Okay. Next one. Is that the criterion for acceptable performance? Increase scores on the language section of MAP. Is that a good criteria? No. Why? Because what if he improves in 1 year's time by, you know, one raw score? Is that improvement? No, it's not. So unless you have an actual score you want to get to, it's really not showing any criterion for acceptable performance. Measurement device, language section of MAP. Well, here's one of the things we know about these large standardized tests. They're not very good for measuring progress. You have to have, you know, just your teacher-made tests or curriculum-based measurements are a lot better than those. Now, here's our ugly. Well, let me go back to this for a second. You can see what they're trying to get at here. They want the student to get better scores on the measures of academic progress. Well, that's legitimate, but the goal is written in such a way you don't know what the score is going to, what the criterion for acceptable performance is. You don't have them saying that what score they want the child to read. So it's not a good goal. It's a bad goal, but it could be a good goal if it was rewritten. Now this, on the other hand, is an ugly goal because there's no way this could be improved. Believe it or not, I took this from an IEP. When required to problem solve on a daily basis, TUCO, it wasn't really TUCO, will reduce by 50% the following behaviors: abandonment issues, verbally aggressive, depression, impulsivity, sibling relating difficulty, destroying property, goes on and on. You know what they did? They did this is what I bet they did. I bet they did like a Achenbach child behavior checklist, and everything that he was low in, I think they just threw it into the goal. Well, that goal is not a goal. How you know? I mean, it just you can't even talk about it because it's such a bad goal. They thought that that was the conditions when required to problem solve. What on earth does that mean? They thought by 50%, well, that's, 50% of what? And that's a measurement device, teacher observation. So that's that's just examples to show you, though, if you just put in those three things, target behavior given or conditions, and criterion for acceptable performance, you can't help but have a measurable goal if you do it correctly. Now, so a sample goal format would be by the time of the next annual review, or by May 16th, 2019, when given a story starter and 3 minutes to write, Jeremy will write 25 correct words, 104 correct word sequences. So in or by is the time. When given would be the condition. The student will, that'll be your target behavior, from what to what is your criterion for acceptable performance, how you know the goal has been met, and then throw in as measured by. And you have that's a good goal format. I mean, if you address all those things and you do them real, unlike the bad goal I just put up, you have a measurable annual goal. You can prove that, I mean, in a hearing, I don't do hearings anymore, but hearing officers, according to the Supreme Court, can ask for a cogent and rational explanation of why you think this goal will enable the student to make progress. Well, if you have goals that you can't measure, that's going to be difficult. Now, the final message in that is both IDEA and Article 7 require that we measure student progress. We react to that information and report progress to the student's parents. Now, remember I talked about formative evaluation, progress monitoring. So important. If, say, the director is up on the stand and the hearing officers, okay, what's your cogent and reasonable explanation for why you think this will enable the child to make progress? If you don't have any way to measure progress, that's going to be a difficult question to answer. Also, we know from research that's been done from the 80s to 2010 that progress monitoring by itself results in increased student achievement. In fact, these folks in 2010 found that just by monitoring progress, you can achieve increase students' reading achievement by almost a whole standard deviation. That is incredible, because that's like if I said, Felicia, I have this program that will raise IQ, and if you come in, your IQ will raise a standard deviation. That would mean like, so if Felicia had 100 IQ, she'd come out with 115 IQ. That's a lot of increase. So progress monitoring is very powerful to increase student achievement. And in fact, the President's Commission on Excellence in Special Education recommended, and that was before IDEA reauthorization, recommended the continuous monitoring of student progress, which shows that has been shown to enhance instructional outcomes and yield results for children. Okay, the purpose of progress monitoring is really to enable IEP teams to improve student performance by allowing them to evaluate the effectiveness of the special ed programming, thus ensuring their students make progress. So if an administrator is up on a due process stand and they say, the hearing officer or the attorney says, what's your cogent and rational explanation for explaining why this will allow the student to make progress? Well, number one, we have a method of progress monitoring. We have measurable goals. The teachers are monitoring student progress by collecting data. If our data shows the child is not doing well, we make changes in the instructional programming. By the way, so the reason for progress monitoring is really to focus us in. Oftentimes we're a little unsure about what the key indicators of growth indicators of student growth are, these give us vital signs. They're like simple and accurate measures that we can use to monitor growth. Standardized tests, not so good for that. Because if you're up on the stand ever and say, well, we're using the Woodcock-Johnson, you can bet your attorney knows the Woodcock-Johnson's horrible, horrible for measuring progress. Can't do it. I mean, it says, maybe you can say, well, it went from 4th grade 3rd month to 5th grade 3rd month. That's not what that means. That is a standard score. I mean, that's a percentile rank. It just means how they compared with a norm sample of kids. It doesn't show what their individual progress was. So for simple curriculum-based type measurements are much better at that. Our legal responsibilities are to measure the student progress on a formative basis. And remember, Article 7 has that language that says, as frequently as kids get report cards, general ed kids get report cards, we have to be monitoring progress toward each of the goals that we write and reporting it to a student's parents. And that should include data. By the way, graphing data, I don't know, one of the things South Carolina has developed we use a program called Enrich. I don't know what program you guys use, but it's our IEP program. It's a
Indiana IEP, and it has,
oh yeah,
you
have the graphing function. Yeah, of course, I remember that. The graphing function is beautiful. It's perfect because that is the most intuitively understandable way to show growth is by just giving a parent a graph. Even if there are the LSP parents that Jim was talking about, if you have a graph that shows progress, that's pretty darn understandable. Believe me, hearing officers are real impressed by that sort of thing. But of course it means if we have that kind of data, we have to revise the child's program if they're not doing very well and continue to monitor progress. So these are a few things. I just real quickly wanted to show you a couple. How many of you read IEPs where you get to the how measured part, it says teacher observation? This is a case out of upstate New York. An IEP was declared to be invalid, not provide FAPE, solely because they didn't measure. What they put down, every single goal was how you measure it, teacher observation. That's all it said. And here's what the judge wrote. Although subjective teacher observation provides valuable information, teacher observation is not an adequate method of monitoring student progress without supporting data. Teacher observation is opinion that cannot be verified. So the message is data needs to be numbers, not words. Here's another case real quickly, again out of New Mexico, using percentages incorrectly. It's not okay to write, Jeremy will increase reading by 90% or increase reading fluency by 90%. If you don't have if you have a percentage, you got to have something you connect that percentage to. You have to have a number, say, given 100 basic words or 100 Dolch words, Jeremy will correctly identify 90. Now that would be measurable, but just say to increase reading by 90% is meaningless. Annual goals that contain percentage of accuracy, not helpful when the IEP fails to define a starting point, an ending point, or the curriculum in which the student will achieve 80 to 85% accuracy. So the whole thing about progress monitoring is about collecting data to determine student progress. Remember, data are numbers, not words. They're objective, not subjective. Everyone can agree on numbers. Data are observable and countable. Now the thing is, then we have to make a decision. We rely on ourselves as our expertise in when we have data, what are we going to do with it? Well, is the student progressing? Do we need to change instruction? That's the kind of thing data tells us. And that's the kind of thing that we can use to prove the substantive correctness or of our IEPs. This is a decision out of New York. Periodic measurement of progress provides the disabled student's teacher with the supportive data needed to make a determination of the success of the program. Now, one last thing I wanted to say. Attorney from Pennsylvania. presented to LRP in 2015, made this statement. When I have a school district with a FAPE case, this Kathleen May found was retired now, but just represented school districts, just like Jim Walsh does. When I have a school district with a FAPE case, the first thing I do is go to the teacher and say, give me information on your student progress. If the student doesn't have data, I advise the school district to settle. That was 2 years before the Andrew decision that changed our standard to progress. So you can think of what is that cogent and reasonable explanation. You need to have data. Now, bringing it all together, and I just wanted to put these last two up to let you know we've got to be internally consistent in our IEPs. Yeah, need has to address a goal. If you have a goal, you have to have a service, and you have to monitor student progress. And the key phrases are based on a student's need, potential for growth. These were all from the Andrew decision. Challenging, ambitious, measurable goals, progress appropriate in light of a student's circumstances. Now, I put a lot of just kind of slides that I'm not going to go through in your, just to show you the way that, give you an example of how one school district in Greenville does their IEPs, and they have a graphic function. We have a graphing function in South Carolina. So we can do things like this. We can set a baseline. We can write the present levels of performance based solely on this information. And by the way, this is a words oral reading fluency, and that's the peers up there. We can write our present levels. We graph it like this, put our baseline down, have a goal line, reaching our goal. That's where we think the child will be given good services in 1 year's time. This is kind of a goal line. From baseline, we want them to get up there. We do frequent measurement. We write our goals based on that, make our decisions based on that, and we collect data. Now, if we have data like that, what's that tell us? Child's not doing so well. We need to make an instructional change. On the other hand, if we have data that looks like this, that's good. We make the decision, report it to parents, child's doing well. Let's keep on doing what we're doing. Can you imagine taking that to a hearing officer and showing him that is just, I mean, that's proof right there that you have written a substantively correct goal. So remember, it's got to be based on students' needs and what we believe the potential for growth is. We want to err on the side of ambition, write goals that are measurable and challenging, appropriate in light of the child's circumstances, and IEPs that are internally consistent. So now we have a few minutes left, right? Yeah. Any questions? Like I said, this information, you know, I have my email if you want to email me or anything. I'd be happy to answer any questions, or I'll be hanging around if you have any other questions.